Good day, Crime Talk aficionados. It's Friday, February 18th of 2022. Let's see what we have on the docket today. First, prosecutors really do not want to go to trial for Lori Vallow and Chad Daybell, at least in Ada County. Kim Potter has her sentencing today. Some people are upset by the sentence imposed. Andrew Cuomo, this guy just can't help himself. This is what a dad does to protect his little TikTok teen. In case you haven't heard, there's a bunch of creeps out there on the internet. Lessons on why you don't give people illegal drugs. And then just about anything you can sue somebody for has become criminal. Is that appropriate? And then finally, our dumb criminal of the day. Let's talk about it. Good day, aficionados. My name is Scott Reich, and this is Crime Talk. Let's get to the docket. Okay, as you may know, the Lori Vallow, Chad Daybell case, the motion for a change of venue has been granted previously by the court. The prosecutors objected. They strenuously objected. And they said, really, Judge, we want to have more time. And the court said, you had your opportunity to present evidence, and you didn't convince me otherwise. But the court said they would wait and see. Well, now the prosecution has filed, and I have a copy of it here in my hot little hands, a supplement and disclosure for the state's motion for the court to allow additional evidence and follow Idaho Code 19-18-16 by transporting a jury. They just don't want to try Lori Vallow and Chad Daybell in Ada County. Now you may say, why? Are the people in Ada County, Idaho, unfair? No. The prosecutors are okay with the jury coming from Ada, Idaho. They just don't want to try the case there. Why, you may ask, Scott? What does Scott always say? It's always about the money. And this is exactly the reason why the prosecutors say, hey, let's just pick a jury in Ada County and let's move them back down here to Fremont County where we can conduct the trial. And how much money is it going to cost? Well, the prosecutors have asked the sheriff to come up with a cost estimate, and it's broken down in their attachments. But basically, they're saying that they're going to have 14 sheriff personnel will have to go to Ada County to cover the trial. That'll be a bailiff in the courtroom, transportation to and from the jail, transportation, security of witnesses, assisting in courtroom as far as door security, and jury transportation, security, and sequestration. All things that, well, the sheriff usually has to do when they're at their home. And what is the cost that the sheriff is estimating that it will cost the good people of Fremont County? $269,430. However, if they just did the jury selection in Ada County and then shipped them back down to Fremont County, it would only cost $53,444, a savings of $215,986. This is a good teachable moment. When you bring high-profile cases, the people that fund the district attorney's offices, usually the county commissioners in which the jurisdiction in which they reside, is responsible for that responsibility. So the district attorney then has to go to the county commissioners and say, hey, we're going to need some more money. And the county commissioner is going to say, wow, this seems kind of expensive because you kind of turned this into a whole big circus. And wow, that's a lot of money. And as my first boss told me in the military when I was saying, sir, do we really want to prosecute this case? The witnesses have since scattered all over the world. It's going to cost a lot of time and money to bring them back. Is it really, really worth it? And you know what my boss told to me then? The colonel looked at me as I was a young lieutenant captain at the time. He looked at me and he said, justice is expensive. Now, the prosecutors should just foot the bill on this particular case. They brought this case. They charged it. They knew it was going to be high publicity when they did it. It's just the cost of doing business. We'll see what the judge will do in this particular case. Judge Boyce seems to get real wishy-washy, and I'm not sure he's going to have the guts to say, no, let's do it. And the prosecution's motion is basically, hey, we asked all these other prosecutors what they've done, and they found no authority that says that it's somehow going to be reversible error if we try the case in Fremont County, and then we picked the jury in Ada County. Well, of course, you have to then consider the disruption to the jurors who are going to have to move to the other side of the state, live in a hotel, possibly be sequestered as well. I hope the judge errs on the side of the jury inconveniences and tells the county to foot the bill. Next on the docket, Kim Potter. Well, her sentencing was this morning, and the now former Minneapolis police officer who shot and killed Dante Wright last April was sentenced to 2 years in prison, which means she'll basically be out in about 14 months after the time that she gets credit for that she's already been in custody. Now, Miss Potter sobbed in court as she addressed Wright's family, saying how sorry she was. And earlier, Wright's family begged the judge to give the maximum sentence, 7 years behind bars. The judge, Regina Chu, said Potter's conduct was significantly less serious than other manslaughter charges. Judge Chu said it is undisputed she never intended to use her firearm. She mistakenly drew her firearm, referring to how Potter was reaching for her taser when she drew for her gun instead. Now, Potter was convicted, as you may recall, last December of first-degree and second-degree manslaughter, and Potter was sentenced only to the most serious charge of first-degree manslaughter because of what they call merger. The less serious offenses merge into the most serious ones. And so, therefore, the presumptive penalty was just over 7 years. Now, ladies and gentlemen, a lot of people don't like sentencing, particularly if you're the victim. I get it. I understand. But there's things called mitigation. And mitigation is not a defense, but it's something that reduces the seriousness of the conduct. And in this particular case, Ms. Potter had, for lack of a better term, a pretty law-abiding life up until this point, until she made a huge mistake. And I always thought it was a case of criminal negligence. I was a little surprised when they found a reckless manslaughter. I just didn't think that was right, but that's for the jury to decide. The reality of it is the judge has to weigh a person's one horrific day based upon their entire good. All right? Listen, nobody wants to be judged for their one moment in time where they've done wrong. Every one of you would like to have somebody look at your entire life if you were to ever get in trouble and say, hey, listen, you're some 50 years old. You've never had more than a speeding ticket, and this is the worst day of their life, and oh my gosh, it's terrible. But for the rest of the part, they're a good person, and they're never going to come back to the criminal justice system. That's what the judge said today. This was a crime. The jury found it as such. The court has an obligation to impose a sentence that is appropriate and no more greater than reasonable, in which to punish as well as deter and make sure that Ms. Potter gets any rehabilitation that she needs. It's unlikely she'll ever handle a gun. She'll never be a police officer. And what good are we going to get from a 7-year sentence versus a 2-year sentence other than just complete retribution? And the other thing that comes in, and I was dealing with this morning, sometimes the court then takes into account the victim. Now, obviously, the victim, it's a tragedy that he's dead. It's a tragedy for his family that he is dead. And this is where the law comes in, where people don't like it sometimes. Yes, he's a human being. But let's face it, the court can take into consideration the fact of Mr. Wright, the fact that he had an active warrant for his arrest, that he didn't comply with the police, and that, he kind of contributed a little bit to the whole situation. The courts can take that into consideration. So, before everybody gets all fired up, remember, I'm telling you the legal analysis, just like we talked about the other day. You got morality and you got legality. People don't always like the two because they don't mix when it comes to court. So, let the wall of hate begin. That's the comments, ladies and gentlemen. Next on the docket, Andrew Cuomo. This guy, he just can't help himself. New information. So a New York State trooper who testified that former Governor Andrew Cuomo, that's right, former because he resigned in disgrace, sexually harassed her, has now filed a lawsuit claiming that Cuomo and his top aide violated federal, state, and civil laws in an attempt to cover up the alleged harassment. The woman, known as Trooper 1, filed a lawsuit yesterday in Manhattan seeking damages against Cuomo, his aides, Melissa DeRosa, and the New York State Police. Trooper 1 claimed that Cuomo tried to kiss her and would bring up sex often in conversations. Trooper 1 said that Cuomo would ask her to find him a girlfriend who could handle pain, and even asked her, "Why don't you wear a dress?" The complaint filed on Thursday also states that Trooper 1, who was part of Cuomo's security detail in September of 2019, accompanied the governor to the Belmont racetrack, where he says she felt violated as the governor intentionally touched her in intimate locations between her breasts and vagina. As Trooper 1 walked ahead of the governor to hold the door open for him, he placed the palm of his hand on her belly button and slid it down across her waist to her right hip where her gun was holstered. That's all according to the complaint. The complaint further alleges that on another occasion, Cuomo ran his fingers down the center of her back and spine, basically from the top of her neck, basically midway down with his pointer finger, and just said, "Hey, you." The lawsuit continues, saying that DeRosa would cover up Cuomo's behavior by giving misleading statements to a reporter from the Albany Times-Union. When the reporter asked about how the trooper was transferred to the governor's security detail, DeRosa yelled at the editor of the Times-Union and accused him of being sexist or even making such an inquiry. The former governor obviously resigned last August, days after it was revealed that he had allegedly sexually harassed nearly a dozen women and worked to retaliate against one of his accusers. Cuomo has denied intentionally mistreating any of his accusers and said he decided to step down to prevent causing more problems and subjecting the state to months of turmoil. Now, the acting Nassau County District Attorney, Joyce Smith, said in a statement in December that an investigation found the allegations against Cuomo deeply credible and also troubling, but not criminal under New York law. I've read that law. I think that they would be potentially criminal when you have a witness that's coming in saying it happened. Let the good governor say it didn't. Let the governor explain that it was just his way of being friendly. Well, several district attorneys in New York said they found Cuomo's accusers credible, but said the available evidence wasn't strong enough to file a criminal charge against him. BS, ladies and gentlemen. If that were you or me running my hands down somebody's back and all that kind of stuff, we'd be criminally charged. Don't you doubt my words. You or me, we'd be charged. But obviously this is a civil case, so we don't have to give the governor any presumption of innocence, but obviously we'll see what his response would be when he responds to the civil filings. I'm sure it will be deny that he never touched anything along those lines. I guess we'll have to see if he pays money like the good prince did the other day to make these little annoyances go away. Next on the docket, this is what a dad does to protect your young teen. A 15-year-old living in Naples, Florida, had amassed over 1.2 million followers on TikTok. One of her followers took a special liking to her in 2020. The person was 18-year-old Eric Justin, and he apparently bought 2 photos of Ava Majuri for $300 via Venmo, even though she had already posted these photos publicly on social media. She states, "I wasn't sending anything of my body," Ava reportedly said. "It was just a picture of my face, which is what I assume that is what he was paying for. My whole thing is my pretty smile. That's my content." But the obsession didn't stop there. Justin reached out to Ava's friends over the years, who also sold him photos of her and eventually sold him her cell phone number. He started requesting booty pics and stuff that the 14-year-old shouldn't be sending. On multiple occasions, Justin begged Ava to unblock him and offered hundreds of dollars to do so. Ava's dad texted Justin, "Hey, she's a minor and you need to not contact her anymore," and notified the authorities. Justin reportedly then texted Ava's classmates that he would breach the door of her home with a shotgun. Ava told her parents, but did not think it was a credible threat, considering Justin lived nowhere near them. But on July 10th, my birthday, 2021, Justin showed up to the family's home with a shotgun and shot the front door. Ava's father, Rob, said he grabbed his own handgun and chased him off the property. While waiting for the police to arrive, Justin returned, pointing the shotgun at Rob, and guess what? Rob asked him to drop the weapon, and Rob shot at Justin. No more Justin. In the police report, the Collier County Sheriff's Office said the subject was most likely a stalker that resulted from her daughter's extensive social media involvement. And Rob said the police told him the shooting was completely justified. I say hear, hear. The Collier County Sheriff's Department did not comment further on the shooting as there's still an ongoing investigation. Now, after sharing her story for the first time this week, Ava explained she's finally speaking out as a way to warn others about the dangers of social media. And Ava's family says they are much more involved now with what she posts on social media. When asked why her parents would allow her back on these sites, her parents replied, it became such a part of her personality, and being that to make it go away would maybe be more harm. Not sure about that, but Justin's father told a news outlet that his son was a nice kid and that he was at a loss for words. He added, I don't know what went bad with him. He made some bad choices. I would say he did. The biggest one, returning back to the house, no doubt. So be careful out there, ladies and gentlemen. It's a crazy world. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. And if that story doesn't convince you that there's a bunch of crazy people out there, wait till you hear about this creep. A 22-year-old man from Florida is charged in connection with the alleged holding up the cue card molestation of a young girl that he met on social media. Brandon Michael White repeatedly preyed on young girls, promising them marijuana and vapes in return for meeting up. Deputies say their investigation began after receiving a report that White had engaged in inappropriate conduct with a 12-year-old girl geared toward, get this, sniffing her feet. Now, beginning in April of 2021, authorities say they learned that there were multiple other victims, ages 13, 14, and 15. In one incident, White is accused of meeting up with a 13 and 15-year-old and asked them to wear stinky socks. The defendant allegedly sexually abused the 13-year-old girl by making her perform a, quote, foot job after promising marijuana edibles. White was thereafter booked into the Pinellas County Jail. He remains there on a $200,000 bond. Court records show that White made his first court appearance yesterday before Judge Michael Andrews, and the Pinellas County court records also show that White was previously arrested for alleged misdemeanor domestic battery. That is quite a little foot fetish he's got going on. Next on the docket, let's talk about Eric Prescott K. Why should we talk about him? Well, he is another teachable moment here on why you do not give illegal substances to another person. Because if you give illegal substances to another person and they die, guess what? You could go to prison, possibly for the rest of your life. So Eric Prescott K is now a former employee for the Los Angeles Angels, and he was found guilty yesterday of supplying the drugs that killed the young and talented left-handed starting pitcher. K faces at least 20 years in prison for his role in the Texas hotel room death of Tyler Skaggs. Authorities received a call on July 1st of 2019 that Skaggs was found dead in his hotel room. The pitcher had a mix of ethanol, fentanyl, and oxycodone in his system. Investigators found pills in his room, including a single blue pill which resembled a 30 milligram oxycodone tablet but had been laced with fentanyl, authorities have said. Now, in an interview with law enforcement, Mr. K denied knowing whether Mr. Skaggs was a drug user. He claimed the last time he had seen Mr. Skaggs was at a hotel check-in on June 30th. However, search of Mr. Skaggs' phone, always the phone that gets him. Well, the search of the phone revealed text messages from June 30 suggesting that he had asked Mr. K to stop by his room with, those pills later that evening. Officials then found texts between the men showing that Kay supplied pills to Skaggs. Now, former Angels player Matt Harvey, C.J. Cron, Michael Marin, and Cameron Bedrosian testified that Kay dealt the blue oxycodone pills to them as well. Kay was convicted of conspiracy to possess with intent to distribute a controlled substance and distribution of a controlled substance resulting in death and serious bodily injury. Sentencing is now set for June 28th, and Mr. K now faces up to 20 years behind prison. The Skaggs family has sued the Los Angeles Angels, asserting the team was negligent. The family attorney stated, "We have no doubt that the Angels knew what Eric Kay was doing, and the team is morally and legally responsible for his conduct." You see how they threw that in? Morally and legally responsible. The morally is to get him to pay. The legally, you should pay if you knew. But if you didn't know, the Angels shouldn't have to pay. Now, the Angels released a statement about the tragedy, but did not mention the lawsuit from the Skaggs family. And the MLB team also noted in the statement, "We are thankful that Major League Baseball and the Major League Baseball Players Association have taken the important step to update their drug policies for players using opioids so that they can actually receive help." All right, next on the docket, let's talk about a case here in Colorado. It involves a plastic surgeon. Looks like he made some serious mistakes, and he should probably be held civilly responsible. The question is, should it be criminal? Now, remember, ladies and gentlemen, normally in criminal law, it was you had to be able to be proven guilty only if the government could prove what was going on in your mind, that you knowingly, you knew what you were doing, you were aware of your conduct, you intended to cause the result. That's the mens rea. Then you have the actus reus, that you actually took the step to do it. Okay? Well, this plastic surgeon is facing manslaughter charges over the death of a 19-year-old patient who died 14 months after he botched her breast surgery. Dr. Jeffrey Kim admitted he didn't call 911 for 5 hours after Miss Nguyen went into cardiac arrest when she was given anesthesia by a nurse by the name of Rex Meeker on August 1st of 2019. Kim turned himself into the Arapahoe County Sheriff's Office on Wednesday and is expected to be charged with negligent homicide, reckless manslaughter, and a misdemeanor obstruction of service. Now, the young lady's parents said that their daughter saved up $6,000 for the breast augmentation to help her self-worth and self-esteem after graduating high school. The family lawyer said that the young lady was left unobserved. No one watched her for about 15 minutes. A nurse comes into the room and finds her blue. During the supposed more than 5 hours, the young lady was lying on the open operating table, according to the attorney, and that the mom was sitting in the waiting room, not knowing about her daughter's condition. The attorney also alleges that when the medics arrived, they used CPR to try to revive the young lady, but she didn't regain consciousness. Now, after the surgery, the young lady was left brain dead and couldn't speak or walk. She was placed in a nursing home and round-the-clock care and was fed through a tube. She died 14 months later. Now, Nurse Rex Meeker is also facing reckless manslaughter charges and is expected to turn herself in on Friday. The young lady's family filed a civil suit against the doctor and the nurse in December of 2019, and the pair both agreed to pay $1 million each. Thank God for insurance. Kim's medical license was suspended on the emergency basis after it was learned the staff waited 5 hours to call 911 after the young lady lost consciousness, but the doctor's license was reinstated under a probationary status. Now, Meeker, the nurse anesthesia, agreed to voluntarily stop administering anesthesia in January, but was allowed to continuing practicing as a nurse. Neither the doctor nor the nurse had any previous disciplinary actions taken against them. Meeker was sued in 2019 after a woman sustained brain damage and died while undergoing a breast implant surgery. Meeker was the nurse anesthetist in that case, and it settled in 2012. So the real question here is, ladies and gentlemen, obviously it's a tragedy, but does criminal negligence arise to the level that it should be held for criminal conduct? Like I said, normally the government has to prove that you intended to do something. Negligence, I have a real problem with this, I've argued this before, is that it reduces the responsibility and the burden of the government to prove the intent, because negligence is based upon what would a reasonable person do, which is civil law. Negligence, what was a reasonable person do? Was it reasonably foreseeable that this action this act could take place, and did you act reasonably in regards to that? Well, be careful what you wish for, because just about anything that you could mess up could be a crime if you want to hold everybody to a negligence standard, ladies and gentlemen. I don't know how this case will come out. I'm not involved in it personally, but I think it's a very, very interesting issue as it relates to reducing the burden of proof for the government. Now, finally, our dumb criminals of the day. Quick recap. Monday, during a search warrant of Chavez Zuniga's items, police found a severed finger in a cloth wrap inside of his wallet. Police added that the finger had pus and blood on it and that the nail was beginning to turn green. Tyler Watson, 29, of Redding, California, was pulled over while being arrested by the Anderson police on a warrant for a probation violation, and they notified officers that he had a live alligator on the floorboard of his vehicle. And who knew? It's actually a crime to have an alligator in your car. Who knew? California, they've thought of everything. Next, Chelsea Alston was told she was too drunk to board a plane in Orlando and tried fleeing on her motorized suitcase, causing a low-speed chase around the airport. You gotta love, what do you get when you get alcohol and a motorized suitcase? Chaos! Thursday, Eric Spencer was arrested for robbing a Chanel store in Manhattan. He had several pictures of the stolen bags on his phone and texts to potential customers. He even tweeted bragging about how he has, quote, so much double C, referring to the Chanel logo, that he could open up a small boutique. There you go. I get it. I get it, sir. Early to bed, early to rise, work like hell and advertise, but not when it's stolen goods. You want to be a little more on the lowdown on that. Just saying. That's your legal advice for the day. And then today, 2 weeks ago, at a mineral show in Tucson, Arizona, a veteran vendor, Eric Miller, noticed that his two ancient Spinosaurus claws from Africa, valued at roughly $25,000 each, were missing. He suspected that the thief might try to sell the claws to another vendor at the mineral show, and that's exactly what happened. Police say Christopher Thomas showed up with the claw to Adam Aronson's booth and tried to sell it to him for a much cheaper price. Miller and Aronson told Thomas they called the police already, and Thomas was arrested and charged with trafficking stolen property. The second claw is still missing, however. Must have gone to another high bidder. Miller said he still plans to attend the mineral shows next year, despite what happened this year. He advised future vendors to take photographs of your expensive items before you show them at shows. Good advice, sir. Good advice. And for our dumb criminal of the day, that's right. Don't go to the same place that you stole something from and try to sell it to the owner. That's just dumb. All right. Thanks for watching. Hope you enjoyed this week's shows. We'll see you next time on Crime Talk.